they're not out of luck. You're only really too late to do anything when somebody doesn't have any assets left to protect. So it's really, it's an area where not a lot of people are familiar with the tools that are available to them. Just as a reminder, we do have some feedback forms for you to fill out. So those will be sent to you after this is over, where you can fill them out, maybe talk about topics you'd like to hear about. It's also a place where you have the ability to set up an initial consultation and let us know that you'd like us to reach out to you if that's something you'd like to do. And before I go too in detail and forget, one of the big things that we have coming up is we are actually in, I believe, August 18th. I think August 18th is our first in-person wills versus trust coming up. So that will be here in Appleton at the DJ Bordini Center through Fox Valley Tech. It's pretty limited capacity. So for that in-person seminar coming up on the 18th of August at the Bordini Center, we recommend you sign up quickly if you want to, and we will get you guys that link. Or the address, so where you can fill out that you would like to attend that in-person seminar. So again, now that I've given some time for everyone to join in, I'll just remind everybody. So I am Attorney Justin Randall here at Hooper Law Office. Our topic today, again, is we're going to be talking about what to do once care has already started for somebody, what you can still do to plan, and the different ways in which somebody might be able to protect assets or potentially stretch out those assets further than they might if they were just sort of spending down once care has started. So a little bit of a refresher from last week, just because this is still really important information to know when you're talking about planning for care, but is the ways in which somebody can pay for care once that's started, and long-term care in particular is what I'm referring to, not necessarily like hospital bills, things like that. So once care has already started, it's too late to really look into long-term care insurance if somebody hasn't already done so and they don't already have that policy. No long-term care insurance provider is going to give you the coverage at that point because you're already receiving care. So they can deny coverage regardless of how much they could charge otherwise. So long-term care insurance is not a great option once somebody has already started care, because it's just most likely unavailable at that point unless that policy was already in place. So there has to be other ways in which someone can plan for care. And I mean, the first and foremost, people can always privately pay, right? That's always an option for individuals to be able to do, but that's not always feasible long-term for everybody. I mean, care is expensive. So when you're looking at the cost of care, even in this area, and by this area, I mean sort of Fox Valley and Wisconsin, right? The range of care, depending on level of care somebody might need, the range of expense can be anywhere from, on the lower end, maybe $5,000 to $6,000 a month, if it's sort of lower end assisted living in terms of need. Memory care and assisted living is usually around $8,000 a month. And long-term or skilled nursing facilities, where it's the most care somebody would need, round the clock kind of availability of somebody to be present and take care of that person, that's probably closer to $10,000 to $11,000 a month. So you can see how easy it would be for even people who have done a really good job saving, a really good job investing, and built up their wealth. It's easy to spend down through that within a couple of years, because that's a lot of money per year. I mean, if you're on the upper end of the skilled nursing, that can be anywhere from $120,000 to $130,000, $140,000 a year in expense if it's that $11,000 a month, right? So it's expensive, and it's not always feasible for everyone to privately pay. So I talked a little bit about these benefits last week too, but they are also very important when it comes to paying for care once it has started. So once somebody doesn't have the ability to privately pay anymore, once they've spent down through what they have, there are different programs available to help cover care costs, but they have limitations to how you qualify for them. So one of which is Medicaid, right? And most people are familiar with how, or have heard of Medicaid. And it's not just for low income individuals that are just, potentially, younger. It's specifically the program that is used to pay for long-term assisted living or skilled nursing stays. So Medicare will only pay for some portion of 100 months. And by that, I mean, they'll pay for, or 100 months, 100 days. But they do not pay for the full value of those 100 days. They only pay a portion of it. So even then it's not fully covered. Once those 100 days are over, that's when Medicare says you have to privately pay now. And so this is where people talk about, well, how do we stop the nursing home from getting our home, or how do we stop the nursing home from taking everything? And the misconception I think people have is that it's not the nursing home taking anything, right? They're not just going in and saying, all right, everything you have is ours. That would not be something they could do. It's more that they're providing care, and that care is expensive. So when people are afraid of losing everything, it's more that they're afraid of losing everything due to that very large expense that's coming up and their income not being enough to cover it. So once though, somebody is concerned about, well, how do we pay for this after we don't have any funds privately anymore, we don't have enough to cover it going forward, that's when Medicaid is one of the primary programs people look at using. And Medicaid has a couple of different qualifications that somebody would need to meet, and those vary depending on whether you are married or single. So there are income qualifications, that meaning your income has to be lower than the cost of care. So the cost of care has to exceed your income. Otherwise, you wouldn't need Medicaid, right? You would be able to privately pay. But they also have asset limitations on how much someone can keep. And those limitations depend a lot on, or how large those amounts you're allowed to keep depend a lot on whether you are married or single. So a single person, it's pretty straightforward. That single person can only keep about $2,000 in assets. They can have a life insurance policy of not more than $1,500, so $1,500 in face value. If the face value exceeds that, they can then look at the cash value, if there is one, as an asset. They can keep their home, but they will have a lien potentially placed on that home as care is provided. They can also keep a vehicle. There's no value cap on that. And they can usually prepay a funeral of up to about $15,000 is kind of there's no hard cap on that. It's just sort of what is it's not recommended to go above that, because Medicaid might take a look at that if somebody has exceeded that. So really, it's not a lot that someone is allowed to keep as a single person. When it comes to their income, once they're receiving Medicaid, all of their income except for $45 a month has to go towards their cost of care. So it is not a lot that someone on Medicaid gets to have available for them. And it's not so much that it's, they're trying to avoid paying for their care, but there's things Medicaid doesn't cover. And that $45 a month is often not enough for that person to supplement what Medicaid does pay for, because $45 a month doesn't get you very far anymore. It may not even get you one meal out to eat, depending on where you go out to eat, right? So single people can't keep really a lot at all. When you're a married couple, that depends on which spouse is receiving care, sometimes how much the healthy spouse gets to keep. So the spouse receiving care, they're still tied to that $2,000 in the personal amount and that $45 a month in income. So all of the rest of the spouse receiving care, their care has to be paid for by their income, or at least supplementing Medicaid's payment rate. The same sort of limitations regarding life insurance, the vehicle, all of that still applies to that spouse who's receiving care. However, what they call the community spouse, so the spouse living at home still potentially and is healthy, there is a different amount that they are allowed to have. And how much they get to keep depends a lot on what types of assets they have, whose name some of those assets might be in. It depends a lot on those and how much they have total to begin with. So Medicaid looks at the community spouse and says that community spouse can keep their qualified retirement accounts, so IRAs, 401ks, any of those types of assets. They can keep any of those, and they're not countable towards the other spouse's available assets if it is in the healthy spouse's name. So, like if it was my IRA and my spouse was receiving care, they could not count my IRA for their care. But the spouse receiving care, their IRA is potentially at risk. So it's just something to be aware of. When we're talking about the other assets that they're allowed to keep, the home is not available either as long as one spouse is still living in it. That is then also protected for, they can't place a lien on it at that time. They can't do anything with it. The community spouse gets to keep that home. The rest that they're allowed to keep depends a lot on how much they have that is still available. So all of the things that are not exempt, they count as available assets. And depending on how much someone has that's available will dictate how much that spouse actually gets to keep. So I'll give a hard number. So there's an example here for you to sort of conceptualize this. But let's say somebody has $200,000 of what Medicaid would say is an available asset. They look at that number and whatever that number is, they divide it in half. So in our example, that would be 100,000 is half of that. Medicaid says of the available assets, the community spouse, they can't force them to spend below $50,000 in available assets, but that community spouse doesn't get to keep more than 130,000 roughly. So in our example, if you fall in that range at all, you keep whatever that half is. So that half of 200,000 being 100, it's pretty much directly smack dab in the middle of that range, right? Or pretty close. If their half was less than $50,000, they still don't have to go below 50. But if somebody had, $500,000, they don't get to keep 250,000 of it. They have to still spend down to the maximum of that 130 that they're allowed to keep. So that 130 or that wherever that spouse falls in that range, it's not counted or it's not calculated using the otherwise exempt assets like the home or the retirement account of the community spouse. Those are not factored into that. So a lot of how much that community spouse gets to keep is going to depend on, like I said, how much is available to begin with, what types of assets are in which spouse's name. So who has more in the qualified retirement accounts. That might dictate how much somebody actually has available to them for their own care later or to live off of as well. The community spouse, I should mention as well, gets to keep all of their income. They don't have to give any of their income towards their spouse's cost of care. So, and it doesn't matter how much that is. I mean, it could be somebody making 10 grand a month that they don't have to give it towards their spouse's care, right? But if they don't have enough income to bring them up to a minimum of about $2,700 a month, then they can keep some of the spouse who's receiving care. They can keep some of their income and supplement their own to bring them up to that minimum amount. It's the idea being that they don't want to impoverish the community spouse completely without having some ability to supplement that. So there's some things that you have to do a lot of times to qualify for this benefit, because a lot of people will say, we have more than that. We would have to spend down quite a bit. We don't currently qualify for this. So there's ways that people can plan to do that and get themselves qualified later. Some people who do nothing, they just sort of start paying and that's it. They spend down to that amount, but there are other options available to someone as well. So before I go into any sort of tools that you would need to use to do any planning, there is also a VA benefit for wartime veterans or their surviving spouses. It's called the VA Improved Pension Program, sometimes referred to as aid and attendance, right? This is a direct pension benefit to a wartime veteran or their surviving spouse that is based off of their income and also has asset limitations as well. So there's service qualifications, one being you had to have been an active duty wartime veteran that served during a wartime period, not afterwards or sort of in between. And they have specific dates that you can see that show if your service qualifies for this. You don't have to have had your service completely within that wartime period. You had to have served for at least 90 days. Only one of those 90 days had to have been during that wartime period. So as an example, I often say, if somebody served their 90 days and 89 of them were after World War II, but one day of active duty was during that wartime period, in theory, they qualify as a wartime veteran. You also can't have been like dishonorably discharged or anything that would lead to a loss of benefits there. But on top of the service-connected service-connected qualifications, there's also the ability for them to look at your income and also what your assets are as well. So kind of like Medicaid, there's income and asset qualifications for this benefit. The benefits, how much you receive, depends on your income, because for just to give you some ballpark estimates, a wartime veteran, if they're married, might get to keep around $2,400 or get about $2,400 a month from this benefit. Surviving spouse might get $1,200 a month as a maximum. But how much of that amount you get is they take your income out of it first. So in theory, if your income is larger than this, you might not receive anything from this benefit. But once someone starts paying for long-term care, those unreimbursed medical expenses can be used to deduct for the VA from your income. So in theory, if somebody's cost of care is exceeding their income, the VA looks at that as if they're making $0 a month. So there's calculations that go into this. So a lot of times, in theory, this can be used for people who are not receiving care too, but it is primarily comes up once somebody is receiving long-term care. The asset qualifications, they made it a little simpler for you than Medicaid did, where it's a set number, no matter whether you're married or single or what types of assets you have. The only exempt asset for the VA is the home, your primary residence, and about 2 acres of land surrounding that residence. I say about because it can be more if it is the local zoning laws say you can't sell a lot under a certain size. So if you lived out in the country somewhere and they said you can't sell a lot under 10 acres, the VA has to, if it's surrounding the home directly, they can't say that, you still only get to keep the 2 acres because they can't force you to sell acreage that you're not allowed to in that area if it's not the right size. So it's 2 acres as a minimum, unless the local laws say that a lot can't be smaller than something larger than that, right? But unlike Medicaid, there's no other exempt assets. The home and that land is the only exempt asset. So it doesn't matter who has the retirement assets. It doesn't matter, the life insurance. It doesn't matter, what is in anybody's name. It's married or single. That $130,000 is still the amount they roughly went with that says you can't have more than that and qualify for this benefit. So these Medicaid and the VA Improved Pension Program are both really nice benefits to have, but they're not always available to everyone right away because of the asset qualifications. So a lot of times people will look at different planning tools to help get qualified. As we mentioned last week, a lot of people are familiar with sort of that 5-year look back period. What that means is that if you gifted anything away or tried to protect anything from your cost of care for Medicaid, they can 5 years from the date of your application for that benefit can look back and demand that you tell them if you gave anything away to try to protect it, or you just didn't get anything in exchange for fair market value for it, right? And that is something you have to do under penalty of fraud for Medicaid. So you can't lie about it. So if somebody is already receiving care, they obviously don't have those 5 years. There's nothing that you can't go back in time and suddenly do it in advance if you haven't already planned in advance. So there are other tools available though that talking with an elder law attorney, somebody who really only does this area of law, is going to be very essential so that you are able to walk through your financial situation or have your family walk through that financial situation and really get the information you need based off of your circumstance to see exactly what can be done to protect things still. And the good news is that if somebody is already receiving care, they're not out of luck. The sooner that somebody comes and talks to us, whether it's they just started receiving care, or maybe they're a year into care, as long as there's assets left to protect, there's still things you can do. And one of the most important ways to ensure that this can be done, because there are plenty of times when maybe you yourself won't be able to, if there's ever capacity concerns, is you have to make sure that you have properly drafted powers of attorney in place at the bare minimum to make sure that this can work. Because with like financial powers of attorney, they're really only as good as the authorities that they grant. So a lot of the issues we see is somebody may have lost capacity, right? They may be receiving care for Alzheimer's or dementia. And so it's just, they're not able to sign new things at this point if it's too far advanced. Well, if they have a well-drafted financial power of attorney that says that their agents can do things like, oh, I can plan around government benefits, or I can, set up certain types of trusts, there's different authorities that they would specifically need. But if it says those things in there and it granted that authority, well, then there's still a chance that your family is able to plan for you and still protect assets. So it's not, if they have those documents in place, there's a lot that they're still able to potentially do. Really, the time where it's a little too late to do anything, I mentioned earlier, if somebody doesn't have the assets that they've spent down already, there's not much else you can do at that point, because you can't get the money back. But there's also the problem that comes up when somebody didn't sign a well-drafted power of attorney before they lost the ability to do so. And maybe they didn't sign one at all, or maybe they signed one, but it was sort of the state statutory form where it's pretty vague. Either way, your agents are not going to have the authorities they need to protect things. They just won't have the authority to do any of that planning potentially. So the first thing you have to do, if you don't have these in place, if you have started to receive care, is while you're still able to work with an attorney, an estate planning attorney, elder law attorney, to get these properly drafted powers of attorney in place, so that whether it's you doing the planning or your agent doing the planning, they have the authority they need to do it. Once somebody needs a guardianship, for example, if there isn't a power of attorney in place, no guardianship court is going to allow your guardian to have the authorities they need to do this planning, because it's not in the government's interest at that point, right? So powers of attorney are absolutely essential in order to do that planning once somebody has started care, if they haven't done it in advance. And the 5 years, just so you know, for Medicaid, and I should say the VA has a look back period as well, but that is 3 years. So these look back periods, they don't apply, and it's not if you did anything, you suddenly have to wait another 5 years or 3 years for the VA before you ever receive care or you receive those benefits. It's not like a 5-year penalty for gifting something. It is just that they can look back that period of time. So there are still tools that somebody has through like a power of attorney for finance that I mentioned, where they can do some gifting strategy potentially, or your revocable trust planning potentially for this, and stretch the money out further. And I should mention too, that this is not about hiding the assets, right? This is not about not paying for care. It's really important to try to pay for as much of your care as you can, because then you have choice over the matter. You have a lot of these facilities are requiring private pay periods. So they'll say like 1 to 2 years, you have to show you can privately pay out of pocket before we'll let you live here on Medicaid, or because Medicaid pays a lower rate than the private pay period is, or private pay rate is, excuse me. So they'll say that you have to privately pay for a certain amount. So that's really important to be able to do if you can. And you generally want to look at privately paying for those 1 to 2 years, because that's usually the requirement. I mean, currently it could always change, right? And that's where long-term care insurance comes in, but it's not always available. So that can be an issue for some people. But once you're past that private pay period, maybe then you look at getting on Medicaid if you've spent down. But the problem is that, like I mentioned earlier, once someone's on Medicaid, they don't have the ability to then supplement their care anymore, because Medicaid does not cover everything. It doesn't cover certain amenities like potentially a cell phone bill or cable if the facility doesn't already provide it, right? It might not pay for the private room rate, and maybe you don't want a roommate when you're 95. I know I don't want a roommate when I'm 95. So I wouldn't blame anybody for wanting to supplement this. But it doesn't cover everything. They'll pay for what they've agreed to pay for with that facility. So by setting assets aside, by doing this protection planning, even once you've started care, you have the ability for your family then, or whoever you trust, to supplement that with those assets. It's not about never touching this money and, protecting it and hiding it. It's about getting the quality of care that you might want still, even after you have spent down to qualify for Medicaid. So there's sort of an ability to have control over the care even after maybe you have spent down to a certain point. You have the ability to have something set aside in the event that you ever have to move facilities, and maybe that new facility requires certain certain private pay period requirements as well. To give an example on that, there was a facility in the area, I believe it was actually, I think it was early on in COVID, kind of March of 2020, if I remember correctly, where this facility went out of business. They went out of business, and everyone living there had to move to a new facility. And they worked to find them a place to live. But what happens to a person who has already spent down? Maybe they met that initial private pay requirement that facility had, but they don't have enough for a new facility. And there's no guarantee that new facility will just say, yep, come live here on Medicaid. Well, this is where setting aside certain assets, using your power of attorney agent, as long as it's drafted, the document is drafted properly, allowing them to have the authorities to be able to do that, is going to provide that person the ability to plan for that contingency of what happens if this facility goes out of business. How do I meet a new private pay requirement? But even if that doesn't happen, how do I get the care that I want in addition to what Medicaid is willing to pay for? Like I said, $45 a month in personal needs, what they call the personal needs allowance, is not really going to cover anything. You can tell that number has not been adjusted since this became law, right? It's the same reason the lower amount that someone gets to keep is still $2,000, which is not really anything. They adjust the upper range for inflation. That 130 goes up every year, but the lower range doesn't. So I can't stress enough, the most important thing that you can do to give yourself the ability to do that planning, or give yourself the ability to have someone else do that planning for you, is to make sure you have at the bare minimum, powers of attorney for finance that are drafted by an estate planning and elder law attorney, not one that you would download off the internet. A good healthcare power of attorney is always important as well, but in terms of the legal planning side of it is less important for the actual, signing of documents and things like that. It's more just for your personal care and your wishes on that front. So it's really something that you even once care has started, there's things that you can do, but it does still require somebody to potentially act quickly because of the expense, right? I mean, it's obviously very expensive to pay for care, so that can dwindle assets quickly. But also, if there's any concern about memory care or Alzheimer's or dementia, I mean, if you don't act quickly while someone still has capacity in that circumstance, it might be too late later. So really, I say it's never too late to do this planning, but there are circumstances in which we just can't do anything at that point. So it's always better to plan in advance if you can, but sometimes unforeseen things come up where somebody might not be able to plan in advance, or, they thought they had 5 to 10 years before they needed care, and then they had a stroke, or they, had some sort of accident that caused a disability, right? I mean, there can be any number of reasons that somebody who would otherwise have not needed care for a long time suddenly does. And so people don't always have 5 years to do this planning, or 3 years for the VA. But if the powers of attorney are drafted while someone has the ability to sign them, and as long as they are drafted properly with the right authorities, you can choose the agents who want to be able to do that planning for you and still set aside money, and stretch it out further. We're running short on time here, so I do just want to remind everybody again, we do have our in-person seminar coming up on August 18th, and I do have the link for that now. So if it's the Eventbrite and free estate planning seminar, wills versus trust. Oh, sorry. I'm being told no, that's not the. Oh, you got it. Okay, sorry. I'm being told by by my sort of voice in my ear that was there. You already got it, so don't worry about it. But yeah, so that is coming up. It's our first in-person seminar since before COVID, I guess now. Seats are limited. So if you want to join in on that, please sign up quickly. I can't guarantee that they'll be there in a week, right? And it is at the DJ Bordini Center here in Appleton, and right by the Fox Valley Tech. So that's just our sort of standard wills versus trust, where we kind of go through a big overview of estate planning in general and the different documents that are very essential and sort of the basics of what different types of estate plans would do for you. And next week, our webinar next week, we are still continuing to do those, is actually going to be, again, more focused on sort of the personal representative side of things, what a personal representative needs to know when they're dealing with someone's probate estate. So if that is something that interests you and you have any or have any family members that are going through that, it's a really good webinar to tune into. But again, if anything we talked about today, you have a loved one that's receiving care already and you want to do anything or see if there's anything that you can do to help them out and protect certain things or plan for care in the future, please feel free to fill out that feedback form we'll send out. Let us know that you'd like to set up an initial consultation. We usually schedule them for about 2 hours. They are complimentary, so you don't pay anything to come talk to us. But if anything we talked about today raises any concerns or potential opportunities for you, please feel free to fill that out. Otherwise, we will see you guys next Wednesday, same time, for our personal representative and what they need to know. Thanks for joining me.